colleagues. I'm Matt Searle, one of the practice directors. I look after the private client team at Outer Temple. The talk today, David Grant and Patrick Thomason are going to take you through will making in difficult times. David's practice incorporates private clients, pensions and commercial in the main, and Patrick's is employment, commercial and private client. They're then going to hand over to Claire Van Overdyke and Alex Cisneros, who are going to take you through the LPAs and statutory wills. Their practices are primarily private client and corporate protection. Claire in particular has a specialism on cross-jurisdictional disputes. And then finally, to finish, Elaine Palzar and Beth Grace are going to take you through mediating in the current climate and hearings. Elaine Palzar's practice incorporates private client, insolvency and professional negligence, and Beth Grace, private client, commercial and employment. If I could now hand over to David to get us started.
Yes, I apologise, there's a bit of background disturbance, but that will finish soon. Good morning, everybody. Thank you for attending today. Patrick and I are going to talk about will formalities. Hopefully you've all had our screens, slides. I'm not going to share them for the duration of the talk, but I'm going to try and put them up briefly now and just take you through them. And then we will take you to one in particular at the appropriate point in the talk. So let me see if I can share that. We're going to be looking why formality is relevant now, the requirements under the Wills Act of 1837, the effect of the English authorities, how one approaches the construction of statutes, judicial attitudes, practically what can we do to mitigate the risk of formal invalidity, and conclusions and thoughts of the future. The slides also have the Section 9 of the Wills Act, which we will put up again in due course, and reference to Law Commission report, which I'm sure many of you will have read before, but is worth reading, and a few of the cases which we'll refer to. So I'm going to now stop sharing. Now, to say that I'm following this talk, we will send out a note of the talk, so don't feel constrained to scribble away as we speak. And as Matt said at the outset, the plan is for questions to be asked of all the talks at the end with the benefit of a cup of coffee or alternative beverage in our hands. Without further ado, I'm going to start. The first question, why the question of formalities is relevant now. Now, it's been much reported, and it's common sense that the coronavirus pandemic has led many people to consider making a will. There are really two situations. One, where the making of the will is urgent for obvious and sad reasons. The other is where people have time on their hands because they're not working or they have fewer commitments and they think they want to regularize their affairs. With all these things, we're interested in your experience of what you've been dealing with your clients over the last 3 months, and hopefully we'll discuss that at the end. The last few centuries, and maybe well before that, will making has centered on in-person interaction contact, the signing, witnessing, and discussing of wills. Social distancing has rendered these in-person instructions and interactions impermissible, or at least undesirable. When I first started thinking about this topic in late March, early April, I thought that we had to take the letter from the Prime Minister of the 29th of March at face value. He said, if you need any reminding, this is why we are giving one simple instruction. You must stay at home. You should not meet friends or relatives who do not live in your home. You may only leave your home for very limited purposes, such as buying food and medicine, exercising once a day and seeking medical attention. You can travel to and from work, but should work from home if you can. When you do have to leave your home, you should ensure whenever possible that you are 2 meters apart from anyone outside of your household. These rules must be observed, so if people break the rules, the police will issue fines and disperse gatherings. I, for one, took those words at face value. The political events of the last 10 days or so have called that into question. It may be that I'm wrong. But either way, the necessity of making and updating wills continues. Now, there's a catch-22 for people who want to make wills in care homes or hospitals, because in a lot of those establishments, there's a practice that health workers cannot witness the signing of wills. That practice is reasonably well recognised. It's commented on by the Law Commission in their report. I've had some anecdotal evidence to say that such requirements have been relaxed in the last 10 or 12 weeks or so. And again, interested for your experiences. But this situation raises the question of what is the purpose of formalities? Now, formalities can have a number of reasons, but paramount amongst them are the following. First of all, to evidence an intention to execute a will. The process, the formal process that one has to go through in making a will is thought to ensure the testator gives proper consideration to the process so that nothing inadvertent or ill thought out becomes someone's will. Also, and this is related, the formalities requirements are there to evidence authenticity and avoid fraud or mistake or the like. Now, there are two approaches one can have to formality requirements: a formalist approach and a functionalist approach. A formalist approach, ensuring compliance on strict rules, can have two consequences. Some people are put off from making wills because it's too cumbersome, costly, and the like. Other wills with innocent defects may not be admitted to probate. A functionalist approach says, well, what's the real rationale for this? And it may well be fairer, but can lead to greater uncertainty and possibly more litigation. So, with all that in mind, what can we do to assist clients? What is the best advice that can be given the last 10 weeks and even now going forward with the relaxations that are happening? And with an eye to a future, how do we predict, can we predict how the courts are going to deal with these issues when they come to court 12 months, 18 months hence? And on that note, I'm going to pass over to Patrick to talk about the formality requirements of the Act, and I'm going to put up the Section 9 for you to look at again. Patrick.
Thank you, David. Now, as I'm sure you all know, the formality requirements for making a will are set out in Section 9 of the Wills Act 1837, which should have just appeared on your screen. Now, this wording is broadly similar to the original 1837 wording. There have been amendments, but it's broadly the same as it was. And in today's talk, I think we'd just like to focus on three of the requirements. The requirement at subsection A, that the will be in writing. The next part of subsection A, that it must be signed by the testator. And the requirement in a couple of places that it must be in the presence of two or more witnesses. Now, the simplest method of executing a will is where the testator signs for themselves in the presence of two witnesses. The witnesses then sign for themselves in the presence of the testator. Everyone's in the same room, sharing the same pen, touching the same paper and furniture, which causes obvious problems. In addition, a beneficiary or their spouse can witness a valid will, but the gift to that beneficiary will be void, which again causes a problem if people are seeking to witness wills within their family unit, who of course they want to leave a gift to. I would also just make two additional points at this stage. The first is there's no dispensing provision within Section 9 of the Wills Act. There's no provision if a formality requirement isn't complied with to nevertheless render the will valid. The effect of the rule is harsh, that if you don't comply, the will is invalid. And the second point I'd just make is that there is provision for something called privileged wills within Section 11 of the Wills Act. And this provides an exemption from the formality requirements of the Wills Act for soldiers in active service, mariners and seamen, but it's a very restricted category. Having just briefly touched on the statute, I'll hand back to David to look at the effect of the English authorities.
Thank you. So, Patrick's helpfully shown the requirements under Section 9 of the Act. There's a vast body of case law on the formalities requirements. That might be thought to be tribute to how complex Section 9 is. It seems to us actually the better way of looking at it is that the sheer volume of case law is a tribute to the ingenuity of clients and their inability or lack of willingness to follow formal requirements to the letter, and also the desire of courts to uphold wills wherever reasonably possible. And the logical conclusion of that judicial desire is in the Supreme Court case of Marley and Rawlings, where famously a husband and wife signed the wrong will, and the Supreme Court held that they were valid. Now, a few points on each of the requirements that we've seen. First of all, in writing, very broad, no restrictions to the material which can be used. They can be handwritten, printed, typed, a combination thereof. No specific language is required. And there's a whole host of wonderful cases, some of which stretching back into the 19th century, dealing with the questions whether a thumbprint can be a signature, it can be. An indecipherable scrawl can be. What about wording which doesn't identify the person explicitly, but says, for example, your loving mother? That has been held to be possible. In terms of other points, a testator can be blind. Testator just has to make or acknowledge a signature. What is acknowledgement? Can it be silence in appropriate circumstances? Yes. Can witnesses be minors? Yes, they can. Case from 1841. So all these cases show the lengths the courts go to try and uphold wills. I'm not going to deal with the requirement of in due presence because Claire and Alex are going to deal with something very similar in the context of LPAs. But I will just flag up the presumption of due compliance. Generally, the courts are resistant to accusations of non-compliance when a will on the face of it looks to be valid. For example, the witness says it wasn't signed by him in the presence of the testator. And it's well established that the courts require the strongest evidence before they depart from an apparently formally valid will. And that presumption has some echoes in the presumption of capacity, which applies in relation to a will which is rational on its face and duly executed. So, the questions raised by the coronavirus pandemic are not new, but they're now more urgent than ever. And the questions are, one, is an electronic copy of a will something in writing? Secondly, can an electronic signature count as a signature? Thirdly, is presence by a video call sufficient? Now, just to pause, when we talk about an electronic will, that can mean at least one of three different things. It can mean a will which has been electronically prepared. The reality is that's how 99% of wills are produced. Someone on a computer, whatever the type of it, whatever the program, typing out a will beforehand. What we're really concerned with is the execution of a will. Can it be executed electronically, or does it have to be typed out, printed and signed? Now, the Law Commission's consultation paper, the reference to which is on the slides and will be in the forthcoming note, gave a provisional answer for all those three questions and answered each of them in the negative. We consider that that was unduly restrictive, and it'll be interesting to see how the Law Commission would have considered the points with the benefit, if that's the right word, of the coronavirus pandemic. Moving on to topic 4 of the talk, the approach to the construction of statutes. It's well known from a whole variety of cases that statutes are always speaking. In other words, the meaning of the statute is not limited by the circumstances which existed at the time of the act's coming into force. Subsequent developments in society, science, technology, attitudes can be considered by the courts when interpreting a statutory provision. And some of the cases we refer to in the slides show the breadth of cases, whether they're criminal, public, regulatory, civil, or the like. To give a few examples, not in a will's context, there's a case called the Crown against Ireland, which considers whether psychiatric injury was actual bodily harm for the purposes of the Offences Against the Persons Act, 1861. The simple point is, back in 1861, our knowledge and understanding and categorization of psychiatric injuries was a world away from what it is today. Were the courts so constrained by medical understanding and approaches at the time? No, they were not. That theme can be seen in a number of the other cases. Technological changes can be considered. For example, whether the photocopy of writing is writing under the Criminal Procedure Act of 1865. So all those cases in their very different ways give some credence to the argument that in looking to see whether an electronic will is valid under the 1837 Act, the courts are not constrained by scientific and technological understandings and circumstances as then existed. And on that note, I'm going to hand over to Patrick to deal with judicial attitudes.
So tying those strands together, we think that it's entirely plausible that a court may uphold a will which has been made through electronic means as a valid will. Now, just considering the points pointing against this view, firstly, and of course, lawmakers in 1837 did not have electronic wills in mind. They had no idea that people would be on Zoom calls, stuck at home, and typing up documents on computers. This cannot have been the intention of the makers of the Act in 1837. And the second point I'd note is that the Law Commission has concluded that it would be preferable to have a new power in primary legislation to allow for electronic wills rather than leaving the law as it is and simply reinterpreting the 1837 Act. That said, we consider that there are factors which point towards a future judge being bold and holding that, in fact, the 1837 Act, the Section 9 of the Act, could encompass a will made through electronic means. I'd just make 3 points. The first is that the words of the 1837 Act are wide enough in a linguistic sense to encompass electronic means. In writing, I'm sure we all consider electronic copies of documents or electronic words in a Word document to be in writing. In the presence of, I think could easily encompass being in the presence of via Zoom. The second point I'd make is that, as David has already covered, statutes are always speaking. They can adapt to current circumstances. And the third issue is the justice of the current situation. If someone has failed to comply with the formality requirements due to social distancing or shielding during the pandemic, I would expect a judge to strive to uphold their testamentary intention. That said, it's fraught with uncertainty. It's very hard to predict, and there is years, centuries of case law which do not provide for electronic wills within Section 9 of the Act. And of course, no one wishes to be a test case. So then thinking about how to mitigate the risk of formal invalidity, what we can do now, of course, the primary advice has to be to strictly comply with the formality requirements of Section 9. This is, for example, neighbours signing while maintaining social distancing, witnessing through car windshields or patio doors or windows. I'm sure we've all heard examples either through clients or through friends and family of people thinking up different methods of signing wills or taking instructions on wills, drafting wills while maintaining social distancing. And this, I think, has to be the primary advice. That said, if that can't be done, if someone can't be in the presence of two or more witnesses, then the best advice is to comply with the formality requirements to the greatest extent possible. Perhaps executing a will through one or more of the electronic methods, whether perhaps the signature is electronic or the will itself is electronic, or if the parties are in each other's presence via Zoom. Now, the best bet would be to limit the reliance on electronic usage to the greatest extent possible in order to maximize the compliance with the formality requirements. Now, this, of course, carries a great deal of risk that the will be found invalid. Alternatively, a person could draft a letter of wishes or could make a deathbed gift, but unfortunately, neither of these provides the certainty of a validly made will. And I would like to now hand back over to David to conclude and provide some thoughts for the future.
Thank you, Patrick. So we hope this talk has been of interest, whether you are probably non-contentious, advisory, or litigators, and whether your practice is limited to private client and quarter protection matters, or also includes broader issues. Hopefully there'll be some resonances for those of you who have to deal, for example, with the Law of Property Miscellaneous Provisions Act and the requirements of executing other documents. The reality is that the formality requirements, as long as they exist, the coronavirus pandemic is going to add to the calls to update or change the ways in which wills are made. That's clearly been a topic at the forefront of the minds of some people over the last few years. Witness the Law Commission consultation. It may well be that the law will change in the future. It may be that current circumstances will accelerate that change, but clearly that is going to be of no assistance to wills which have been made in the last 10 weeks and may be made in the next few months, however long the period in question is. It remains to be seen exactly how these pan out. As I said at the beginning, we are very interested in seeing your experience in how matters have been dealt with by clients. But the concluding point Patrick's already touched on is that the only safe advice one can give is to, if at all possible, comply unarguably and unequivocally with the requirements of Section 9 of the 1837 Act. If that is not possible, one should ensure that such deviations from it are as few and as minor as possible. Thank you very much, and we'll now hand over to Claire and Alex.
Thank you, David. So Alex and I are going to be discussing LPAs, both normal LPAs and business LPAs, and then statutory wills. I'm just going to share my screen with you so you can see the slides that we'll be looking at. Give me one moment. Here we go. So in relation to remote execution of LPAs, I'll be addressing that. Alex will be discussing business LPAs, and I'll finally touch on statutory wills during the pandemic and how to approach those from a practical perspective. Looking to England and Wales, I specify England and Wales separately here because I will be doing a comparison with what's been happening in Scotland in relation to LPAs and a remote execution of them. But specifically with regards to the way we've approached it here in England and Wales, I'm not going to cover the issues that David and Patrick have when it comes to the remote execution of wills, because that applies equally to LPAs, because they're regarded to be deeds similarly to, or deed documents similar to wills. So I'm just really going to focus on the peculiarities of the situation that we're in with regards to LPAs, bearing in mind that there are two aspects that are affected by the current pandemic. That's the completion of the certificate provider form, and second of all, the actual witnessing of the LPA itself, with a focus on what the Office of the Public Guardian has been saying in its official guidance issued at the end of April as to how we should be approaching LPAs in the current situation. So looking to the certificate provider situation first, I mean, as those of you who work in mental capacity or generally speaking with LPAs, you'll know that this is to confirm the donor's capacity to make an LPA, and also to confirm that there's no fraud or undue influence that's been used to induce the donor to create an LPA. And this is somebody that should be known to the donor for at least 2 years, or someone with a relevant professional qualification. And importantly, they can't be a member of the donor's family. So given the current restrictions, although them having been lifted recently, given the current restrictions with the distance that people can meet, it's going to be difficult to find someone to act in this capacity. As a point of reference, the solicitor who drafts the LPA can also act as certificate provider if they satisfy the requirements of eligibility. And ordinarily, the certificate would be given following a face-to-face meeting. But the OPG's guidance, which I'll take you to in a moment, suggests that it might be possible to communicate with the donor in a different way, such as by phone or video call, to be able to satisfy themselves, essentially, that the donor understands the scope and the purpose of the LPA, and that there's no ulterior matters in the background, such as fraud or undue pressure, or anything else that would prevent the LPA from being created. Now, it's going to be quite difficult, I think, to be able to fully ascertain these issues as a certificate provider, because you're going to be restricted to assessing the situation through a video screen or a phone call. And so knowing what's happening in the household of the donor, particularly if there may be a concern that someone's exerting pressure, is going to be quite difficult to put a finger on, really. So that's something that I think is going to be very particular to each individual that you're assessing, and also knowing that not one size doesn't fit all, really. So a careful approach is going to be required. With regards to witnessing of LPAs, again, similar issues arise here compared to wills, which have been discussed already. Here we need to have the signature of the donor and the signature of the attorneys being witnessed. And what the OPG has effectively said is that, well, the headline note, I should say, is that you should delay making an LPA until the social distancing rules have been relaxed. So the OPG recommends using the time that you have, lots of time on our hands at the moment, to talk to others about your wishes, think about what you might want to include in your LPA, and then start to complete the forms, but don't actually make the LPA unless you absolutely have to. And if you have to make the LPA, what they suggest is that you should basically follow the guidance of the government, which is that you need to make sure that you do not have, you can't use video calls, such as Skype or FaceTime, and signatures must be witnessed in person. And a case from Senior Judge Lush from 2011, as he was then, specifically in the case of LPAs, has been referred to by the court recently, which refers to the early cases of Shires and Glasscock and Casson and Dade from 1688 and 1781 respectively. And that is that an instrument is properly executed so long as the person witnessing the signatures has a line of sight of the person signing. So essentially, you as long as you follow that, then you can have a proper witnessing or execution of the LPA. But specifically, digital signatures, they say, should not be used. The document must be printed out and signed by hand with a black pen. Photocopies of scans of the LPA cannot be sent, so everyone has to sign the same original document in a specific order. So you have to have the donor signing it first, then a certificate provider, and then the attorneys and the replacement attorneys. So this is obviously creating quite a lot of difficulty for individuals presently who are concerned about their future, and obviously looking for peace of mind to know that if they do lack capacity in any given moment, whether it's because of illness, physical illness such as COVID-19 or anything to do with their mental health, that their affairs will be taken care of. And the message is that it's going to be quite difficult for them to have that assurance. The OPG has suggested that what they should do instead is to make an ordinary power of attorney or third-party mandate to allow individuals to access their finances, and to basically work that way. But how does that give reassurance that the person needs? And that also leaves their finances open to abuse, specifically if there is any doubt as to whether or not that individual lacks capacity at any given time, because we all very well know that financial institutions will freeze accounts if there's any concern that an individual may lack capacity to manage their finances. So this is all really quite difficult, I think, for those who are advising people to make LPAs at the moment, and also for individuals who really want to plan for their future. In terms of actually what the government is doing to change the guidance of the law for LPAs, is very much linked to wills. There have been a number of questions posed to Parliament during March and April of this year, asking what's happening with regards to the developments, particularly what the government is going to be doing about the recommendations of the Law Commission report. And the consistent response has been that they are looking into it and essentially looking into whether or not it's going to be possible to have video witnessing of documents, but highlighting that essentially the important safeguards in the law at the moment are there to protect the elderly and protect individuals against undue influence and fraud, as we well know. So there's not much of a balance to be struck at the moment. It's very much a case of wait and see and a question of government priorities. So just to compare what's been happening then from across the border in Scotland, it's a very different approach, actually. I don't know whether any of you have had any experience of working with Scottish cases recently, but the Law Society of Scotland and the Office of the Public Guardian up there acted very promptly in early April, 8th of April in fact, to agree a 6-stage virtual execution procedure by way of video conferences for LPAs. And this was premised on the basis that it will rarely be appropriate to delay the fulfillment of an instruction to have a power of attorney registered and granted. So quite different to what the OPG is saying down here. In Scotland, they're saying an LPA, if someone wants to make it, should be allowed to make it without any delay. Just to briefly go through the 6 steps that they've identified that you should follow to make an LPA. The first step is that this solicitor provides to the donor the document in advance, either by post or whether the client has facilities to print it off by email, preferably a PDF version that can't be altered. Then the donor shouldn't sign the document in advance of the interview, but show the solicitor via video conference that the document is unsigned prior to the interview itself. Then the interview will take place and all the normal requirements would follow, that you would have a face-to-face meeting. And if all the normal criteria are met and the solicitor is satisfied that a document can be certified, then the donor should be requested to sign the document and the witness should sign as appropriate. And the witness obviously being in a separate forum. And the client should then be instructed to promptly return the hard signed copy to the solicitor. And then the solicitor would register the document once the principal wet ink copy is received. So it is obviously a jigsaw puzzle, putting together all these pieces to have one composite document that is signed with a wet signature, but can be done through video assessment and video links. It does clarify, though, that this would only probably be appropriate, this obviously depends on how the courts approach it too in terms of looking at this matter retrospectively, where the client is an existing client and the practitioner is satisfied that the client has capacity and there is no undue influence and no other vitiating factor. So if you're looking at a new client situation, the professional obligations to ascertain all those issues of capacity, undue influence, etc., is going to be that much more difficult when you have no physical meeting. But in any event, they obviously haven't managed to progress matters up there. And having spoken to some colleagues who work in Scotland, it seems to be that actually that has encouraged people to make LPAs up there, not more than usual certainly, but certainly not to delay making them as is being suggested down here in England. Just as a point of reference, there are many other states around the world at the moment that have, similar to Scotland, introduced emergency laws to allow remote execution of LPAs. If you're interested in terms of how they've approached it, Alex and I have written a paper discussing all these issues, but particularly looking at the different jurisdictions and how they've approached matters. And that will be sent to you after this talk. We've looked at Canada, Australia, and the USA, both from a federal level and from New York and Florida. I'm going to move on, ask Alex to move on to business LPAs now, and then I will finish off with statutory wills.
Thank you. So I'm going to be speaking briefly about business LPAs, which are slightly unusual powers. That they are obviously what they do on the tin is what they do. They are simply a lasting power of attorney to give an attorney authority to manage someone's affairs related to a business. I say they're slightly unusual. You'll appreciate the usual use for the lasting power of attorney mechanism is for someone's personal finances or health and welfare. But I thought this current situation was quite a good example of why pre-planning, particularly for businesses, is useful. And that is because if a client is worried about losing capacity in the future, or actually just being worried about being unavailable to manage their business at some point in the future, it's quite a useful mechanism to have it stored away somewhere such that someone else can take over for continuity of business affairs effectively. The reality is that without this sort of plan, and I say some sort of plan tucked away in a back drawer, a business's bank accounts can be frozen or loans or overdrafts recalled. If a person does lack capacity and they're managing a business, they won't be able to enter into legally enforceable contracts on behalf of that business. And depending on the type of business the person is engaged in, that there may actually be intervention from regulatory bodies. So it is worth considering as a client, as a lawyer, sort of advising a client who owns a business or manages a business as to whether a business LPA is appropriate for them. There is obviously the backup plan that if someone doesn't have a business LPA, you can always make an application to the Court of Protection to appoint a deputy to manage this person's affairs related to their business. But the reality is, and the most recent figures from the Court of Protection are that property and affairs applications such as this typically take around 47.7 weeks to conclude. So the reality is that it's not going to be a particularly useful application for a deputy to be appointed where a business needs continuity in the interim, and therefore that's an added benefit of having an LPA which can be executed and take over as soon as the need arises. So in dealing and advising on business LPAs, in addition to what Claire's spoken about in terms of executing an LPA more generally at the moment, I have 3 considerations that you might want to bear in mind when advising a client specifically about business LPAs. And the first relates to the slide that hopefully is in front of you at the moment, which is the type of business the donor is engaged in. Thank you, Claire. So effectively, you need to consider the type of business they're engaged in as to whether an LPA will be useful and or capable of enabling attorneys to act on their behalf. So the first example is if the client is a sole trader. And in that situation, the business is highly unlikely to have a separate legal entity. So appointing an attorney on behalf of whoever is the sole trader is highly likely to be an effective way to make provision for continuity of the business, because the attorney will just step into the shoes of this sole trader and continue to manage the business as if they were the person, obviously in the best interest of that person. The second aspect is slightly different and is linked to the third, so partnership. Looking at the appropriateness of an LPA for partnership, you'd have to look at the partnership agreement, because it's that document that will determine whether an LPA is appropriate. And similarly, for directors of a company, it's the Articles of Association that will be the first point of call. A partnership agreement or the Articles of Association will usually make provision for what happens if someone loses capacity. So the model Articles of Association, for example, provide for the termination of a director's appointment if they lose capacity. So in those situations, it's probably not likely that an LPA will be useful to manage someone's business affairs if actually their directorship is terminated. So you don't need to provide for that, but it will really depend on the agreement or Articles of Association. So moving to the next slide, which is my second top tip or consideration, and that is when drafting or advising about a business LPA, it's highly advisable, and more than advisable actually, it's necessary to keep the person's business affairs very separate from their private affairs. And that's simply because there is a duty on attorneys and those advising attorneys to avoid conflicts of interest from arising. And that is born out of the Mental Capacity Act Code of Practice at paragraph 7.60, whereby it sets out effectively that there is a fiduciary duty on attorneys to make sure that they don't take advantage of their position or be seen to take advantage. And so therefore there is a duty on them to avoid conflicts of interest from arising. So I say it's important to keep business affairs separate from private affairs, so that there is not a question ever of the two types of appointment as an attorney from overlapping. And as a lawyer advising clients about this, as well as the duty that the attorneys would be under, there's also a practical consideration, because Senior Judge Luscious, he was then, in the case of Re JW, looked at the duty to avoid a conflict of interest and said, actually, where there is a question of an apparent conflict or a real conflict, if anyone raises an issue with how an attorney is appointed, then the Court of Protection will step in. And in that situation, the Court of Protection will then make or review the decisions that have been made by that attorney to determine whether there has been any inappropriateness born out of a conflict of interest. And the obvious thing for me that jumps out from that is you will be before the Court of Protection, which can potentially be quite expensive if there is a question of conflict of interest. So better to preempt all of that and make sure that there can be no question of conflict arising by keeping the donors' affairs separate. Now, practically how that can be done, obviously the first thing would be that you can execute two separate LPA instruments, one for private affairs and one for business affairs. I was asked a question as to whether that is allowed. The answer to that is, if you look to the lasting power of attorneys regulations, there are model forms at the end in, I think, Schedule 1 or 2. And those model forms sort of assume that people may have more than one power of attorney instrument, because there's a little box that says, is this your only power of attorney instrument? Do you have any others related to your property and affairs? And you tick that or whatever. And so, yes, it is allowed to have more than one instrument dealing with two different aspects of someone's life. The second practical bit of advice would be that you could have a different certificate provider or different witnesses for a private LPA as opposed to the business LPA. And that is just so that there can be no question in the future about an overlap between the two areas of someone's life. So moving to the third and final consideration or piece of advice in terms of advising about business LPAs, which is the final slide. And that is, thank you, and that is in relation to the instrument itself and the words you put into it to make sure that the donor or your client, the person who's making this LPA, their opinions and their desires about their business are adhered to. So the first point about this is that alongside the LPA instrument itself, you can draft a deed or a memorandum of wishes to express what the donor's views are about how the LPA should operate. So that document can then be stored with the LPA and almost provide guidance to the attorneys in the future if they need to step in and manage the person's business. That document will be useful to them, is an indication of how the donor wishes for their affairs to be managed. This slide talks to the specific wording that you can put in instructions to attorneys, and it's just a word of caution arising out of the case I was involved in last year, re various powers of attorney. I don't think I put the citation there, but anyway, the citation is 2019 EWCOP 40, in which the court made it clear, the senior judge made it clear, that you can't put instructions in an LPA which would bind an attorney to act in a way that may actually be contrary to the to the donor's best interests. So you need to be careful in not making wording in an LPA instrument too prescriptive, such that it may actually prevent the attorney from acting in the way that they should in the future. So in that way, any instruction should be drafted in precautionary terms rather than mandatory terms. And there's just two examples there of lasting power of attorney instructions that have been deemed to be inappropriate for that reason. The other point to make about wording in an LPA is that, or rather, this is an example of a lasting power of attorney that did try and sort of combine the two areas of someone's life, whereby the wording used in the LPA instrument purported to give the attorneys power over both someone's private affairs and someone's business affairs, and that's in the case of Reed Black. Again, Senior Judge Lush, as he then was, discussed this, and effectively in that case, the LPA gave the attorney, or purported to, that power which the court found would isn't appropriate effectively, and would be incompatible with joint and several appointments. So again, there's an importance to be careful, or you need to consider what wording you use and what power you're purporting to give the LPA in determining whether the lasting power of attorney instrument will be held to be valid. Because the danger is a court or the Office of the Public Guardian will just say this isn't a validly executed, or this isn't in the correct form, and therefore it's not a valid instrument that confers no authority. So again, the reality is that a client may be left with nothing. So those are my considerations in terms of advising a client about business LPAs. I'm now going to pass back to Claire, who's going to talk about statutory wills during COVID.
Thanks, Alex. So statutory wills have been in the spotlight the past few months as well, because for those of you who don't practice in court of protection law, it's essentially a will that's made on behalf of somebody who lacks capacity to make the will themselves, and it's effectively authorised by the court of protection. So there are a number of circumstances in which a statutory will could be required in current circumstances. It might be that that someone is critically ill and will die intestate if there is no will in place, although that doesn't necessarily mean that it should be made. You'd have to show that that person did not have an intention to die intestate. It may be that P, the person who lacks capacity, has recently made a will in a hospital setting or in a care home, and there's a dispute about whether or not he or she had the capacity to make it. And it's better to resolve that during that person's lifetime rather than leaving it to a contested probate dispute after the person has died. And another example is that it may be that the executor of the will or the beneficiary has died and there are inadequate replacements. So a lot of practical circumstances that can arise that need to be addressed quite quickly, especially if the person is critically ill. And the court has recognised that statutory will applications can become urgent and require quick resolution in the current pandemic. And the court service in its family business priorities list for April of 2020 and leading into May and June of what work must be done includes statutory wills. So there's three tiers: is the work that must be done, the work that the courts will do its best to complete, and the work so the work that must be done, the work that will be done, and the work that they will do their best to complete. So I won't go through all the different categories in terms of how they're populated, but essentially statutory wills are up there with urgent applications and serious medical treatment cases, just to give you the context. At the bottom of the list, for further context, are court of protection property and affairs cases. So, for example, like Alex mentioned, an LPA application, 47 weeks is pretty much what we're looking at. But not only that, it's at the bottom of the list of priorities. And we do know from updates from the court that there is currently a 3-month pilot that started at the beginning of May for the making of applications electronically. And that the court is expected to report back on how that pilot has been carried out at the beginning of July. So, there is some progress really for non-urgent applications. But clearly a significant period of time to await the outcome of property and affairs matters. But looking back to statutory wills, of course, one of the main issues with obtaining a statutory will is the person's capacity to make the will. And if there's any uncertainty over this, then it's going to be a question of applying to the court for an interim will, so an interim statutory will, which would effectively hold over in case the person dies before the application is concluded. Now, there's a certain threshold, obviously, that the court has to be satisfied of, and there has to be an assessment of P's testamentary capacity. But bearing in mind the practical circumstances that we're in, essentially highlighted by the Vice President's guidance on visiting protected persons in any setting, that was in April, where he said that visits should only be made to P where that is assessed as absolutely necessary, and alternative arrangements should always be considered first, such as telephone, FaceTime, Skype conferencing, and visits to care homes to be strongly discouraged. That hasn't changed despite the lifting of the restrictions somewhat since early this week. And certainly from my experience of dealing with COP cases over the past couple of months, is that it's a huge divergence between how certain care homes are approaching access to facilities, video conferencing, FaceTime, etc. And I know a few care homes that are only looking into that now, where it's literally been just telephone contact that residents have been having. So the extent to which you can really actually have an assessment of that person's capacity in their circumstances is going to be very specific to where they are. I mean, we know that there are companies out there that have been readily carrying out assessments by video technology or telephone, such as TSF Consultants, Halcyon Doctors, for example. I mean, they've made it quite clear that they are up and running and doing a lot of assessments. But if you can't have that assessment by way of face-to-face video time, for example, you're going to have to consider a desktop port by a GP or a private practitioner, that person reviewing P's medical notes and making an assessment on this basis. That would really only be suitable where the person cannot be assessed because there's no facility for it, or they are in a coma, for example, with a traumatic brain injury, or intubated because of COVID-19. You're really going to have a good justification for having a desktop report, although that will probably be enough to reach the lower threshold for a holding statutory will, so an interim statutory will, until the court is in a position to have better evidence as to capacity. And so really that's what the court has been doing quite a lot of recently, is making holding wills. The threshold for that is section 48 of the Mental Capacity Act, just interim order. And the wording is that there is reason to believe that P lacks testamentary capacity. So not enough to be a section 15 declaration the person does, but also that is in their best interest for the will to be authorised without delay. The idea is that in the meantime, before it's made final, all of the evidence is finalised and reaches that higher threshold. But if the person dies in the interim, then that holding will effectively be treated as a final will for the purposes of probate. Query, of course, what will happen after the person has died in terms of how that might be challenged in the probate courts. But it is the most that can be done, I think, in those circumstances where you have those difficulties in actually having a full assessment of someone's testamentary capacity, and at the same time a compelling reason to have a will made for them while they're still alive, obviously with the authorization of the Court of Protection. That concludes our talk. Of course, we'll be willing to answer any questions you have at the end. But now I'm going to hand over to Elaine, who's going to talk about mediation.
Before I took part in my first remote mediation, I was very skeptical. I was convinced it was going to be inferior to in-person mediation. But it actually worked extremely well. What really surprised me is I came away thinking, is this actually even better than in-person mediation, which really surprised me. I'd love to hear what all of you think about remote mediation, if any of you have taken part. A lot of people seem to be saying that they've had positive experiences of remote mediation, which is good news, because according to the 2018 CEDA mediation audit, 89% of cases settle by way of mediation, 74% at the mediation itself, and 15% shortly thereafter. So I think it's good news if remote mediation works well, because it means we can continue to settle cases. I'm going to look at 5 things: the process of mediation, the advantages of it, the challenges of it, and then finish off with a few top tips and a quick look at the future of mediation. In terms of the process, you need something like Zoom in order to do remote mediation. There are lots of video conferencing facilities out there, but you really need one that has the breakout rooms. So just like with in-person mediation, you need to be able to put the parties and the lawyers in separate rooms and have the chance to come together if you need to. It's easy enough to text the mediator when you want him or her to come back into the room, or for he or she to text you. You can also, with something like Zoom, use screen sharing, which can be helpful if you want to share the terms of a settlement agreement where you're tweaking the terms with all your clients. You, or at least the mediator, might need a digital signature facility. Of course, you can just sign the mediation agreement in the usual way and scan it and send it back. If you have clients who might not be able to manage that, then a digital signature facility like DocuSign or rSign, which allows for an electronic signature, might be helpful. You'll probably be using an electronic bundle, although you don't have to. But if you do, then you'll probably want 2 screens so that you can continue actually seeing everybody while looking at the bundle, drafting the agreement, as the case may be. The advantages of mediation, or doing it remotely, are obviously that we can still carry on settling cases, which is great, so that we can continue to help our clients. Location's a big factor. It works really well. Doesn't matter where the parties are located in the world or their lawyers, you can all come together very easily. It's good for people who are elderly or infirm, and that's likely to be the case even once we'll get past the virus. Even once some of the restrictions are listed, it's likely people who are elderly or have weakened immune systems will still want to do remote mediation rather than risk coming together to do a face-to-face one. It's probably good for clients who may be more of an introvert disposition. If you think about it, face-to-face mediation is really quite full on. You're surrounded by people constantly in a small room for sometimes 12 hours with very little chance of escape. So it's good, I think, to think about your client and what might actually suit them. Are they likely to prefer something more remote? Are they elderly or infirm? That kind of thing will suit them. It's also probably more comfortable being at home. You don't even need to do it in your house. You can sit in your garden and mediate remotely. It's much easier to go and take a break, have a walk if you're at home. You can even have your pet with you. I've heard that people have been doing remote mediation with their pets, and that's been very therapeutic and more conducive to a settlement. So there's plenty of advantages. There are also obviously the advantage of not wasting time traveling, no travel costs, no venue costs, no accommodation costs, no fancy sandwiches costs. So it works really well. There's plenty of advantages. I'm going to look now at the challenges posed both by the virus and by the remote process itself. As far as disclosure is concerned, at the moment, it might not be possible to complete disclosure because you might not actually be able to go and get all the physical files with the lockdown. So I had a trial that was adjourned because we couldn't get the third-party disclosure in time. But for mediation, you don't have to have every fact, document, and argument sorted. So I don't think any possible restrictions on disclosure should stop you. Similarly, with witness statements, you may not obviously be able to go and see your client in person or go through the documents together, but you don't even need witness statements to mediate. It may even be advantageous. You can say, I've got X number of witnesses who are going to say X, Y, and Z, and you can put that quite confidently. Whereas if you actually have witness statements, there's more chance people will be picking holes in the evidence. So I don't think that needs to stop remote mediation either. When I prepared these notes a couple of weeks ago, my main worry was expert evidence, particularly valuation and being able to sell the property. So with our kind of private client cases, there's inevitably some kind of property that has to be sold. Quite often, for example, in Inheritance Act case, you'll need to know how much the property is worth. It may be that you need to find a smaller property for someone, so you need to be able to get valuations. That's, I don't think, such a problem now, at least in terms of the residential property market. Although I still expect it's going to be sluggish. There's probably not that many people are going out thinking, oh great, let's go and buy a house and move at the moment. So it's a little bit more volatile. I still think commercial property is a little bit more risky. That doesn't come into it as much with our kind of work. But businesses could be closed at the moment. So it's difficult then for a surveyor to get in and assess the position. Some tenants aren't paying rent at the moment. So how do you value a commercial property in that kind of situation? You might not really have comparables because nothing's being sold or very little is being sold at the moment. So that makes it more difficult from the commercial property perspective. The court may also delay valuation to late in the day, and if you don't get a valuation done, that might delay mediation as well. That doesn't mean you can't rely on historic valuation, possibly something like Zoopla or drive-by valuation. So there are possibilities, but that could be a hindrance. And similarly, if people don't think a property can be sold, that might slow them down a little bit in terms of wanting to get on with mediation. There are also challenges posed by the remote process itself. So for a mediator, I mean, mediation is quite an emotive experience. It's important for the mediator to develop a rapport with the parties, really kind of get into their heads, understand their concerns, try and find common ground. And it's quite difficult over Zoom to kind of pick up on those non-verbal cues. It's not impossible, but it's a little bit more of a challenge. And also something like eye contact. I think if I want to make eye contact with you, I'm supposed to look straight into the camera. But if I'm doing that, then I might be looking into your eyes, but I'm looking into the camera. So it's not really possible to develop, to have eye contact in that same way. You also obviously have this little video of yourself all the time. And if you like me, you're probably checking all the time, or maybe it's just me, checking you look okay, you're sitting all right, etc. Whereas in person with mediation, you don't have this mirror of yourself, an added distraction. So it's not the end of the world, but it is obviously, it's a different way of communicating and there are additional challenges. Some people find screens quite tiring. I mean, you can always switch the camera off some of the time and you can take breaks. I think in-person mediation is pretty tiring as well. The last challenge, I think, from the remote process is how easy it is simply to disconnect and leave. So there's a little button at the bottom that says leave meeting. So if you have quite an emotional client, it's very easy to say, I've had enough, boom, they go. Whereas at least in person, it's harder to go away, I think, if you're with somebody than on a computer. And similarly, at least if you're in person, you can go after the person. So that is a risk, but hopefully the mediator will be able to manage things so that that's less likely. It's certainly not a reason to stop mediating remotely. In terms of a few top tips, I would test the software ahead of time. Obviously, if you're using Zoom, you'll know how to use it. Just check how the breakout rooms work and make sure the parties know what to do. I would be inclined to draft the settlement agreement ahead of time, or a few variations of it to save time. Draft a proposed order, any deed of variation. Do your risk analysis of the merits so that you've got an idea of your range of possible offers. But also, particularly at this time, consider the vulnerability of the other side. It's not just a case of what's the risk analysis. If they're particularly vulnerable because of the virus and their financial position, it may be that you can get a better deal. Also think about the costs, because it may be that even if your client is successful, they may end up not being able to recover the costs from the other side, because the other side might not have anything. So that may be the amount by which you want to settle for, regardless of the merits. So it's also quite a pragmatic approach that's needed. What about the future for mediation? There's likely to be this avalanche of cases coming, or so everyone keeps saying, because of the virus. Frustration cases, force majeure, breach of contract, landlord and tenant, insolvency cases. And that may mean that there's a delay to getting a trial. That might mean that it's better to mediate. But also, if you wait, will the other side even be solvent by the end of it? Another reason why you might want to mediate remotely. In terms of the case law, the Halsey case says the court can't force the parties to mediate. It's possible that that might change if there's this avalanche and the courts are swamped and there's a delay. The Lomax case says although the court can't force you to mediate, they can compel you to do an early neutral evaluation. Query if that might increase if the courts are overwhelmed. I prefer mediation because I think you've got more control than with an early neutral evaluation. So finally, I think remote mediation is likely to be a big thing in the future, at least for the next year or so, because of the avalanche of cases, because of the court delays, because 89% of cases are settled by mediation, and because the remote process really does, I think, work extremely well. I'd love to hear what you all have, your experiences are of remote mediation, but first I'm going to hand over to Beth, who's going to talk about remote hearings. So if your mediation fails and you have to go to court, Beth will tell you what to do.
Thanks, Elaine. I'm just going to share my screen. So yes, I'm going to talk about remote hearings during COVID-19. And I know that a number of you, including Hayley and Scott, have had some fairly lengthy remote hearings, I think. So please do chip in if there's anything you'd like to add. For me, remote hearings come in two forms, as aptly represented by my dogs. They are available if anybody wants to hire them. Now, the court's approach in reality turns around a number of official documents and pieces of guidance. I'm not going to dwell on those because I'm sure you're familiar with them. But even if you've not seen them, and there are two pieces of guidance that were released yesterday, I've put the links on the slide. And the key message is, whether or not a hearing is going to be remote or hybrid or a normal physical hearing will be a judicial decision, and the majority of hearings will still be remote. So this talk isn't out of date yet, which is a good sign. Now, in practice, the courts are being very pragmatic. The overall approach is on fairness. And you see that in the Court of Appeal's recent judgment in B, which was about an interim care order. And in that case, they decided the matter wasn't suitable for a remote hearing. But a number of matters have been suitable. And these cases on this slide are something to take into account if you want an adjournment or if you suspect an adjournment might be granted. Smith Technologies did grant an adjournment, but re-won Blackfriars, no adjournment at all. And that was a 5-week case that is now going to be heard remotely. And it's interesting to look at that judgment because you see there that the court took absolutely no excuses, from health and safety to coronavirus infection to not having the tech capability to do a 5-week remote hearing. The court didn't accept any of it, and that hearing is going ahead as far as I'm aware. But what I really want to focus on today are the practical challenges for us. How do we replicate things like team working and client care when we have to work at a distance from each other? So one of the things I've been thinking about, in particular, things like bundles and the way that we interact with them when we're in court. Quite often somebody will turn up a page and you can also see it, and then you turn it up and so on. That's now gone. And also the virtual huddle, which for me is really, really quite important, because it's that moment before we start the trial. We have some last minute strategizing, the legal team, the client, and then we go with confidence into the courtroom. So what I'm trying to do is to make some time for that on Zoom or whichever platform you and the client are comfortable with, so that we can just get into that huddle before a hearing and make sure that we're all on the same page before we begin. But I think one of the biggest challenges we have as lawyers is actually preparing the client for a remote hearing. And these are some of the issues and questions I've been thinking about. For example, is it the same as having your day in court? Now, for a lot of clients, that's actually very important, but it does depend on the client, because as Elena said, some clients will really quite like to be away from the alien environment of the courtroom and maybe in their garden while having a very contentious trial. But others really like to be there. They like to see the witnesses being cross-examined. They like to sit with the legal team. They like to be very involved. And for those clients, actually, there's a risk that they could come out of that hearing thinking that it was very anticlimactic. So we do have to prepare clients for that distinction between feeling something's anticlimactic because of the way that it's played out on a video call, and the outcome, which is quite a different thing. The outcome could still be very, very positive for the client, but the client may not necessarily get that. Cross-examination as well is likely to be very different when it's done remotely. It's likely to be short, sharp, focused. Body language is read differently. The judge may respond differently. And you may also have to deal with a client who is not very familiar with technology. And that can all have an effect on the way that they give their best evidence. So if you have the time and you have a witness who's being cross-examined, it might be a good idea to at least have a session on the video platform that's being used, so that you can iron out any difficulties and you can make the client comfortable with the way that they need to present themselves over video. We also need to prepare our clients for an increased potential for adjournment. I have to say that my experience, in fact, is that the majority of my hearings are being adjourned. I have tried to persuade judges to hear short hearings remotely. And one judge in particular, that was a completely ridiculous idea. And I really wish I'd referred that judge to one Blackfriars, but I didn't. So we do need to prepare the client, particularly at the end of a case that's been ongoing for some time. And a lot of our private client work is like that. These disputes have been going on sometimes for years, that the day that they hope they'd get a resolution may not in fact appear. I want to come on to some tips and tricks. Don't panic if you don't have a judge on the other side of the computer. Now, really happy for people to chip in if they want to, or to comment afterwards. But one of the things that I think is quite important and quite self-evident is to agree the video platform in advance. It does appear on the cause list, but of course, if you've not liaised with the other side, by the time it's on the cause list, it's a little bit too late. I think if you have the possibility of doing so, try to get it in the recital of one of the case management orders if you can, because then everyone's on the same page. And also think about which formats will work best for you and the client. In particular, I think Mr. Justice Mostyn has identified there's an issue with Skype for Business, which means you need to stop the recording every 30 minutes to prevent file corruption. So if you're using Skype for Business, bear that in mind. Tell the judge that you're aware of that. As Elaine's also mentioned, multiple screens can be helpful. I tend to use one screen, and in part the reason for that is if I've got two computers, I'll be pressing the mouse on the wrong computer and then wondering what's broken. But I think multiple screens generally do tend to work better. In terms of using technology to your advantage, you can consider using hyperlinking in skeletons and witness statements, just to take the judge to the correct part of the bundle or to the correct authority. I know that David recently was in the interim applications court and noticed that the judge was actually Googling the CPR. Now, if you're referring to the white book and you have a linked skeleton, for example, you can ensure that the judge is immediately on the same page as you. So that can be a useful trick for getting everybody to be singing from the same hymn sheet, as it were. Another thing that people have had a lot of success with is using WhatsApp as a virtual post-it note and having separate groups. So perhaps client and solicitor, solicitor and counsel. If you have leading counsel, then junior counsel and leading counsel, to ensure that the information filters up. And actually, Patrick has tried this and said that he preferred it to using a post-it note, and that he may go on to use it in the future anyway. So I think that's something that may stick around. Even if you're doing a remote hearing, remember that it's still a public hearing. The press can still attend. This happened to me recently in a hearing in the High Court. I didn't really know the press were on the line until they put the phone down. And that was quite disconcerting, because it was pretty good indication that the hearing was really quite dry and procedural. But in any event, do remember that. Also remember the judge's clerk can help. Get their email address in advance of the hearing, because if for some reason the call drops, and this does tend to happen sometimes quite randomly, the judge's clerk is the person who can get you back online. Similarly, if there's an issue with the bundle or any sort of issue, they're the person to contact. And the final thing is learn how to mute your sound or stop your video at a moment's notice. I think this is something that many of my colleagues have learned from bitter experience to date. There have been stories of geese, dogs, children, parents interrupting hearings, including one unnamed father who came into the room while his daughter was on a hearing, tripped over the laptop cable, started swearing. I think this is one of those moments when you realise that thankfully the people that you're dealing with in these very interesting times are also all human. But yeah, so those in summary are my tips and tricks. And I'd be really interested to hear from anyone who has anything to add. I'd also just like to do a quick plug for our remote hearing guidance, which is available on the website and is being updated. So if you have any further queries or questions, please ask them now, or alternatively, do go and check to see what resources are available on the Chamber's website.
Okay, thanks for taking the time out today to listen.